All right, let's go to Dewana Lane versus M Entertainment. So the posture we're in, we had an initial hearing regarding the amount of fees to be awarded. I asked that Mr. Freed supplement the record, which he has done. I invited Mr. Kasdorf to respond to that, which he also has done. I am prepared to rule on this, but I wanted to give the parties one final opportunity to address anything that they need, or that they feel they need to address to me. But I have read all the documentation and the responses, and also give Mr. Kasdorf, if he would like, an opportunity to question Mr. Freed about the fees. I don't believe that, based on what Mr. Kasdorf you have submitted in your papers, that you have any specific questions for Mr. Freed. I think you've laid out your objections and concerns very well, but if you want that opportunity, I will give that to you. So first, I'm going to ask Mr. Freed if there's anything supplemental or anything you wish to add other than what you've already submitted, which I have read.
No, Your Honor. I think the supplemental briefs and my affidavit speaks for themselves.
All right. And Mr. Kasdorf, is there anything you wish to add, or do you wish to question Mr. Freed about anything relating to the affidavits?
No, Your Honor. I think that the matter is reasonably presented on the papers, and I don't think I need to ask Mr. Freed any questions. I'm not gonna, as this court knows, we've not disputed Mr. Freed's rate or in general the quality of his legal services. We just think that a court's review of the hours spent on the motion for sanctions will conclude that that's an unreasonable amount of hours, and I'm not gonna sort of insult Mr. Freed by questioning every bit of that time. I think the court just needs to make a determination as its own professional judgment about what a reasonable amount of hours to bill on that project was.
All right. So let me just, I want to address some of the issues that you have raised. First, about excessive hours on the sanctions motion. I got a very detailed and extensive notebook. I think perhaps even more than one notebook when we had the updated sanctions motion, detailing the history of this case, the testimony, the discovery issues, the prior case. We got the video. There was extensive work done on this case and on the sanctions motion because there were extensive issues. And I think all of that work was necessary and appropriate to advise the court of the extent of the conduct and all of the surrounding circumstances. So I agree, it was a lot of time, but also I note that there was a substantial record produced. There was a lot to show for the time spent in preparing the motion for sanctions and the updated motion for sanctions. So I do not believe the hours sought are excessive. The other issue that was raised was that the fees should begin to accrue at the time that I advised orally that 9/15/14 might be in play. And I will just say this. Before I award sanctions, I usually like to give some folks a warning and say, hey, we're going down a dangerous road here. sanctions may be in play if you continue to push this without basis or for unnecessary and unreasonable delay. And the fact is that if after that hearing, there was a voluntary dismissal, and I recognize it would be with prejudice, but if plaintiff's attorneys had let the lawsuit go, the motion for sanctions and fees would have been denied. But that didn't happen. And what we got after that was, at best, a half-hearted effort to hold the claim. No substantive, cognizable legal theory, inadmissible evidence, and continued to force the defendants in this case to defend against the lawsuit. And the lawsuit, it wasn't minor. This wasn't a fender bender. This is a death case. This is something that had the potential to result in huge damages. So they had to defend it, and they had to defend it vigorously. And you defend things, and then you point it out to the other side, and they say, okay, we give. And if they give, then you did your job, and you earned your fee from your clients, and everybody goes their separate ways. But they did their job, and the plaintiff's attorneys in this case were not dissuaded. And so the consequences are that they flow from when they knew they did not have a cognizable theory. I don't fault for saying, hey, there was a crossfire, and that's how he got killed at the beginning. But once you do your diligence, and once you do your discovery and decide you don't have that theory, and you can't come up with another cognizable legal theory of recovery, you got to give up. And that just didn't happen. So I'm going to award fees in the amount requested as modified by Mr. Freed's subsequent affidavit, in the amount requested of $219,038.77. That will be my order in judgment. I think, Mr. Freed, y'all submitted a proposed order before we dealt with the amount, which I have not entered. I'd like to enter one order that deals with both the reasons for awarding the sanction and dealing with the amount of the sanction. So I'm going to ask if you would to submit a revised proposed order that includes the amount and how that was calculated.
We will do that, Your Honor. Thank you. Maybe we have it full early next week.
That's absolutely fine. And again, run it by Mr. Kastorf so he can approve as to form. I suspect this may not be the last we hear of this issue. So Mr. Kastorf, you can approve it as to form, and then you and your clients can your options from there. All right. Unless there are any further questions, I think we're concluded. You all may be excused.
Thank you, Your Honor.
Happy holidays.